let me open with a word of prayer. Our Father, our God, we thank you for this day. We thank you for the gift of life. We thank you for the opportunity to live in a country where we can peaceably assemble and where we can discuss the issues of importance to us, where we are not excluded from participation in government, but indeed have been given an awesome responsibility. I pray, Father, that you tonight would give me clarity in my thoughts and my words, that you would give understanding to those who are listening. We thank you for those at Grace Chapel who have so willingly provided this place for us to meet and the services that would allow us to do this, Father, to go out over the internet and not have to run around the state. So we thank you for that. We ask your blessing, your hand of favor upon Pastor Steve and the staff and the folks here at this good place in the body of Christ. Bless our time together this evening and accomplish all your holy purpose. In Jesus' name, amen. Being at the legislature is sort of like a reality show that has all the excitement of anything you would want to find on network TV. In fact, the hot topics down in the legislature don't come in second to what takes place on the television. We have fights about marriage issues. We have fights about sex issues, abortion issues, and religion. Everything you want to see on network television, we do down at the Legislative Plaza for about 4 months out of the year. And those categories are actually the categories that I'll be talking about tonight, because that's the focus of our organization, the Family Action Council of Tennessee. There are a lot of issues that I'm personally interested in, our board members are personally interested in, but we focus on issues of marriage, family life, and religious liberty. I want to spend a fair amount of our time talking tonight in the first part of our program on the issue of marriage. There are not too many bills related to marriage that are down there, but there are some. And I want to cover one of them for you just real briefly. And I want to cover this bill because it's one of those things, and often what you find in politics is that there are things that are well-intentioned, they have a good heart, and they sound good, but they have issues that have to be addressed. And boy, I tell you what, over the last several months, I have particularly seen that. There are a lot of pieces of legislation that make you want to shout and cheer and hoorah that, wow, I like that. And then as you began to dig into it, you find that there are issues that you just didn't notice. And that's a function we want to serve for you with the experience that we have, the legal background that we have, is to help you better understand some of the things that are there that may seem to be good. Now, this bill right here is by my good friends, Senator Janice Bowling and Micah Van Husk, and it would prevent public officials in their official capacity from solemnizing weddings. In Tennessee, to get married, you have to get a marriage license, and certain people, by virtue of that license, are, quote, authorized to marry you. That's sort of the thing that deputizes the person to marry you. I could conduct a marriage tonight right here, but in the absence of a license, it would be meaningless unless somebody has had a license issued naming me as the person who can marry you. So under the law, ministers, spiritual leaders, those having care of souls is the words that's used, and various public officials can solemnize marriages. Now, many public officials are more concerned than ministers about being asked to marry people because they're government officials, and I'm afraid I'll be asked, and if I don't, then I can be sued because I'm not really a pastor with a First Amendment religious issue, maybe, right? And so there's a natural tendency to want to say, well, let's just take these officials out of the list of persons that can solemnize, and let's not have somebody go to them and set them up. I hate to tell you, but there are mean people in the world who will set you up for problems. And they will go to you specifically and say, will you marry me, knowing you won't? And then they run to the newspaper and say, oh, so-and-so is such a mean person, they won't marry me. And then they use that in the campaign against the elected official. So this is a very understandable bill, but what it essentially does is it now only allows ministers to marry people. And some would say, well, that's wonderful. Then everybody that wants to get married is going to go have to find a spiritual leader to get married. Isn't that great? Well, that's what we call the establishment of religion. If the only people that can marry you are religious people and you force everybody to go to a religious person, then you've probably violated the establishment clause. So a very well-intentioned bill, one that we would tend to want to be eager to support because we want to keep elected officials, good officials, from being made to look bad unnecessarily, because we want to encourage people to seek the spiritual meaning of marriage, but we run afoul of the Constitution. How many of y'all knew that a lawsuit had been filed in Williamson County over the marriage issue? Okay, the vast majority of you have. Some of you may have been on a conference call I held a couple of weeks ago where I explained some of this, but because it is a bit difficult, I thought it would be helpful to go over it, even if some of you have heard some of this before. If you want to know about the lawsuit, though, on the slide up here is a link to our website. There is a slider about the lawsuit, and pretty much everything you want to know about the lawsuit is there. So if at the end of tonight's program you didn't follow something, you want to know something more, it is there. I want to start the discussion of the Obergefell case and this lawsuit with 3 observations. One of the things that's become apparent to me is I deal with legislators in particular, it's unfortunate, is that many haven't thought about the Constitution really since 8th grade civics class. And about all they know is what they were taught in 8th grade civics class, which isn't very deep because it's 8th grade civics class. And so there's some things that we often forget if we ever knew them that are important to understand and that explain these lawsuits. I was just reading an article today about me in the new civil rights movement.org that talked about the insane attorney from Williamson County who is pathetic, insane, hasn't read the Constitution, probably hasn't read the decision. I can't remember some of the other words they used. And as I read it, I thought he probably hasn't read the decision either. And so here are some of the observations. Court decisions only bind the parties to a lawsuit. That seems kind of elementary, but we have to remember that. There may be a lawsuit between me and person X, and what has happened between me and person X may be very similar to what has happened, almost maybe identical, between me and you. But the lawsuit between me and X does not have any binding effect on you. You weren't the party. That's very important, and we'll explain why in a moment. Court decisions may be precedent, but they only bind as the particular issue before the court. So let me go back to my example where I'm suing person X over a contract issue. I have the exact same contract with you. Let's say it's a recording contract. I always wanted to be a singer, a musician. And so I have a recording contract, and I win in this lawsuit. You're sitting over here saying, gosh, if David sues me, I will probably lose because this case will be precedent for my case. But until I actually sue you, until the court actually says, yes, this is exactly the same thing, we don't really know what will happen over there. Now, why that is important is oftentimes the Supreme Court will rule on something, and everybody will say, well, that's just like our law. So we're just going to do what the court says. When theoretically, you could always say, well, I know my law is exactly like their law, but I'm going to make them sue me. I'm going to make them prove their case. I'm going to make them win against me. Now, often you don't do that because you wind up paying attorney's fees for yourself and attorney's fees for the other side, and you're going to lose. But theoretically, you can do that. When the Supreme Court in Obergefell ruled on the laws of 4 states, only those 4 states were affected by that judgment. Every other state's law is valid until somebody sues them and actually strikes it down, or until their legislature decides to change the law anyway. But that's important to understand. And the only case in Tennessee that was in front of the Supreme Court last summer was the case of Tanco v. Haslam. There were 4 cases, one from Tennessee, Ohio, Michigan, and Kentucky. We're all in the 6th Circuit. Our case was called Tanco v. Haslam. They were all decided under the name of the case, Obergefell v. Hodges, which was a case in Ohio. But each of those cases involved different laws, and so decided different questions for each state. So let's take a look. The only laws challenged in Tanco were laws regarding out-of-state marriages. So the only law that Tennessee has been sued over, the only law that we would say legally and constitutionally has been adjudicated is our law dealing with people who live in another state, get married, and move here. That's the only law Tennessee has been a party to. That's the only decision that's been made with respect to Tennessee law. The question that was not decided in the Tanco case is what's the legal effect of that court decision on marriage license laws for in-state people, the 2 people who live down the street from you. That law was not challenged in Tanco. It was challenged in the Ohio case and in the Michigan case, but we're not Ohio and we're not Michigan. While what the court said about those laws would be precedent in a lawsuit against our laws, those laws in Tennessee have not yet been ruled on. So, what did the Obergefell court hold? And here's the importance of the holding. You've probably been to marriages where the minister gave up a little homily for maybe 5 or 6 minutes, said, by the power vested in me, you're married. You've been to some places where they maybe went through all of covenantal theology from the beginning of the covenant with Adam, and an hour and a half later they got to the marital covenant. But at the bottom line, they still had a holding, right? By the power vested in me, you're married. All that stuff from the 3 minutes to the 3 hours is all nice stuff, but you have to look at the holding. And so what did the Supreme Court hold? Well, they held, and this is a quote, the state laws are held invalid to the extent that exclude same-sex couples from civil marriage on the same terms and conditions as opposite-sex couples. They said the laws are held invalid. Now, I saw a couple of you, not over the internet, I can't see you, I promise, but kind of like, the laws are invalid to the extent. What does that mean? Well, let me just put for you what our law says. Our law says this, quote, no county clerk or deputy clerk shall issue a marriage license until the applicants make an application in writing stating the names, addresses, ages, addresses, social security numbers of both the proposed male and female contracting parties. Now, I don't know who's listening on the internet, but I know most of the folks in here, and apart from me and from Zach, I don't think there are any lawyers in the room. So you're at a great handicap to read that statute and say, does that seem to exclude same-sex couples from marriage because it says there has to be a male and a female? Now, I know that's a tough thing. Put on your thinking caps, and you would probably say, yeah, when Bob and Fred, I don't know which one's going to be the female. When Susie and Sally show up, I'm not sure which one's going to be the male. That would mean, therefore, it would appear that the law is invalid because it excludes same-sex couples. Brilliant. You just graduated from law school ahead of most lawyers in the country. I mean, when after all, lawyers don't know what the word is, it's probably hard to figure out some of this other stuff. But look at the contradiction of what the court said. The court has a second holding, and here's what they said a few paragraphs later. They said, this court in this decision holds same-sex couples may exercise the fundamental right to marry in all states. Now, they just said this, right? We hold the laws are invalid. We hold that you can get married under the law. That leaves us with two questions. How do you exercise a right to marry, which was the second holding, under a law that under the first holding has been held invalid? How do you get a valid marriage license if the law is invalid? And then there's this other interesting thing. I was talking with Zach today, who's a lawyer, and so sometimes we have lawyery discussions. And he said he was talking with some of his other law friends about the statement that the law is held invalid to an extent. How is a law invalid to an extent? Can a law be more or less constitutional? Now, I know that all of you in this room have either had a mother or you are a mother. And I would like to ask the women, have you ever known a woman who was pregnant to an extent? More or less pregnant? No. What's very interesting is Chief Justice John Marshall, who wrote the Marbury versus Madison decision that gave us this concept of the judiciary reviewing laws to determine their constitutionality. He said, a measure may be more or less wise, depending on the circumstances, but it can never be more or less constitutional. And you know where I found that statement was I found that statement in the majority opinion in a case from 2011 called NFIB versus Sebelius. That's the case in which the Supreme Court said that Congress could not threaten states by withholding money if they did not expand Medicaid. That was an attempt to commandeer a state government to dictate to them what they should do, and it was in violation of the principles of federalism. And it was in that case that I read that quote, and in that opinion, it was joined by Justice Kagan and Breyer, who are two of the judges who wrote that the law is invalid to an extent. A law can't be more or less constitutional, but it can be constitutional to an extent. Do you see some of the irrationality and illogic that we're finding in our court? That begins to happen when you try to reach a result and then figure out how to get back to the answer. Now, let's take a look at Tennessee marriage laws. Okay, we've already put this up there, but let's work through this for just a moment. Here's the statute we've already looked at. It says that to get an application, no clerk can issue an application unless it has the name of a male and female on it. So if the words male and female are invalid, which is what the Supreme Court said, right? They said state laws that exclude are invalid. Then what words took their place? There's the statute. There are the words male and female. If those words are invalid, what words took their place? Who can be the contracting parties now? And who can insert words in a statute? Well, let's take a look at that for a moment. Under the state constitution, only the General Assembly can prescribe the duties of a clerk. The Constitution of Tennessee says the qualified voters of each county shall elect for terms of 4 years a county clerk. Their duties shall be prescribed by the General Assembly. They're not prescribed by the governor. They're not prescribed by the Supreme Court. They're not prescribed by Congress. They're prescribed by the General Assembly. If the General Assembly passes no laws giving the clerk anything to do, then the clerk gets elected every 4 years and sits at home. They sit at home because there's no duty, so there's no budget, so they can't even have an office to go sit in. On the basis of what law passed by the General Assembly can a clerk issue a license to anybody if the law is invalid? Which Obergefell held. On the basis of what law prescribed by the General Assembly are our county clerks issuing any marriage licenses to anybody? Well, okay, what law? What's the law? Where is the law? Let's find it. You remember the little Wendy's commercial, those of you in the room that are over 50s? Where's the beef? Where's the beef? Remember, well, where's the law? I want to see the law. Where's the law? Well, here, there are two answers to this question as to how the clerk can be issuing licenses. Again, here is the statute. And the question would be, well, can you just simply elid, that's a nice legal word we use, or delete, the words male and female, and then interpret the remaining words, contracting parties, to mean any two people regardless of their sex. So as you see in the statute, if we just take the words male and female out of the statute, it says the security, the names and so on and so forth of the proposed contracting parties. Well, that's the law. There it is. That's it, Dave. You just take those words out. Well, there's a problem with that. Interestingly, the two cases that dealt with in-state marriage license laws, Michigan and Ohio, both have references to man-woman or male-female. And the court did not analyze those statutes. It's very interesting. They didn't say, well, here's the statute, and here's what you do. You just take the word man and woman out, and voila, you have the rest of the statute, and that's how you get married, holding number 2. There's the law. They didn't do that. Very interesting. In most cases, like in abortion cases where there's a provision about the doctor doing something or whatever it is, they quote the statute and they say, well, here's the key word, and you take the word out and all that, and they interpret the statute. They didn't do that in this case. Why did they not? Why did they not? Why didn't they tell us, here's how you get to this new law? Other than just saying, you can get married, why didn't they say, well, here's how? They didn't explain it for us. Well, let me tell you why they didn't. There's this doctrine of elision. The United States Supreme Court has cases that are exactly like this. They use the word separability or severability, which is the concept of can you elid, can you separate, can you segregate out invalid words, unconstitutional parts, and just uphold what's left. The Tennessee Supreme Court last March said, when a conclusion can be reached that the legislature would have enacted the act in question with the unconstitutional, the invalid, part omitted, then elision of the unconstitutional portion is appropriate. In other words, here's the question. When I said, can you just take the words male and female out of the statute, the question is, well, if the legislature had passed it without those words, if those words were removed, would the legislature have enacted the law anyway? Well, do you think when the General Assembly passed the law in 1995, it would have enacted it if the remaining words, contracting parties, could have included 2 men or 2 women? Now, before you answer that question, let me tell you that sodomy was a crime. Would the legislature have authorized a marriage that would have been a crime to engage in? Now, they do some crazy things, but not that crazy. How do I know that for sure? Because I voted for that law in 1995. It was my first year in the General Assembly. In 1996, the State Court of Appeals said your sodomy statute is unconstitutional. It's unconstitutional to make sodomy a crime. You know what we did in 1996? We passed the Defense of Marriage Act. that said, hey, in 1995, we said you had to be a male and a female, and in 1996, the next year, we came back 4 months after the Supreme Court, or the court struck down our sodomy statute and said, by the way, we meant man and woman. We really did mean that. How do I know that? Because I voted for it. I was the one defending it on the floor. The answer to this question, can you take the words out, is no, no, no. It would have never been passed. Why did the Supreme Court not go through this analysis? Because they would have known the answer. Nobody would have passed these marriage statutes at the time they passed them if it was going to allow same-sex marriage. Their own court precedent would require them to say the whole statute's unconstitutional. You can't just take those words out. So they just kind of over it. So we're not going to get into it. We're not going to explain it like we might normally because we'd get in trouble. We'd have to start overruling years and years and years of precedent on whether you can take words out of a statute. So there's that answer. Well, what's the other answer? Okay, we're issuing marriage licenses. What's the law? Well, here's a second possible answer. What did the court say? The court said, we hold same-sex couples may exercise the right to marry. So the Supreme Court just passes the law. Your law is invalid. It's gone. It's unconstitutional. You can't elide and delete the words male and female and save the statute. It's just gone. So we'll just pass a new one for you. We'll tell you what to do. The problem, my friends, is that's the court effectively enacting a new marriage license law to replace the one it said was invalid. And that's a violation of federalism and the separation of powers. That is an unconstitutional act by the United States Supreme Court, contrary to its own cases, upholding the doctrine of federalism, NFIB versus Sebelius, and separation of powers. Now, I would like to tell you that I'm some kind of genius for thinking about this, but actually the Alabama Supreme Court has a case that's pending in front of it right now. You may have read about some of the stuff Judge Roy Moore is doing. And liberals are going nuts every time he does something, but there's nothing they can do about it because he is legally, constitutionally correct. And what the Alabama Supreme Court said last March in a 6-1 opinion that did not even include Judge Roy Moore. So those of you who are listening don't think, well, this is just crazy Judge Roy Moore. No, Judge Roy Moore sat out this case. He recused himself. So this is 6-1 of the other non-Judge Roy Moore people, okay? Now, I'm not saying that in denigration of Judge Roy Moore, but to let you know, this wasn't Judge Roy Moore leading some charge down here. Now, what had happened back last year in March was a federal judge had said, you have to issue same-sex marriage licenses. And so a lawsuit was brought and said, well, that judge is only able to tell the parties in the lawsuit what to do. Remember the first thing we said? You got to remember, if I sue Enoch, that has nothing to do with what Zach has to do. It's just me and Enoch. And the Alabama Supreme Court stepped in and said, yes, one federal judge is not God over everybody, and he can only bind the parties in front of the case. And so the rest of you people in Alabama who issue marriage licenses, obey the law of Alabama until the Supreme Court rules, and then we'll figure it out. But in that decision, they said this. They said the contemplated change in the definition of the term marriage so as to make it mean something antithetical to what was intended. In other words, when you delete the words male and female from the law to say that means now 2 men and 2 women can marry, that's antithetical to what was meant, what was intended. We're a legislative body. We can't change the meaning of a statute. If a statute's meaning and purpose is going to be changed, we can't do that. We're a judicial body. The Alabama legislature must do it. And he said, so therefore that means it would appear to require nothing short of striking down the entire statutory scheme. If you're going to say those words male and female are invalid, then you got to say the whole thing's invalid. And then they said this: the alternative appears to allow the judiciary to declare by judicial fiat a new statutory scheme in place of the old, rather than leaving it to the legislative branch to decide what should take the place of the scheme being stricken. Who knows? Now that the statute's invalid, Alabama might say, we want to be able to marry red elephants. As long as you don't want to marry a war eagle. Or maybe it'd be vice versa. I don't know. We don't know what the Alabama legislature would do once their law is ruled invalid. But the Alabama Supreme Court saying, but whatever it is, it's not our job to do it. That is contrary, it says, to well-established state and federal principles of judicial review. So Obergefell has some constitutional problems we have to understand. It violates the separation of powers in that a judicial body is enacting a state statute. That's what they have done. And that violates the precedents regarding federalism, which prohibits commandeering state officials and branches of state government. Now, on our lawsuit page, you will see this flowchart, and it's a little hard for y'all to see here and probably impossible to see on the internet. But I want to blow up the key part of that slide, and I hope folks at home can see it. But essentially, there are 4 different things that can happen, and they pretty much all lead to the same result. And the key part is on the far right-hand side, the 3 boxes. If the state courts of Tennessee do what they should do, they should really do one of 2 things. They should say Obergefell was an unconstitutional exercise of judicial power. That means it's void ab initio, a nice Latin term, and therefore should be disregarded. Just like the marriage license law, or a marriage license you got last August, it might have well gotten a piece of toilet paper. The law was invalid, the license was invalid, your marriage was invalid. Everything's invalid. You don't get something valid out of something that's invalid at the root. Or they can say, well, we can't ignore the decision, it's there, but the Supreme Court said the law's invalid, so the law's invalid. Nobody can get a marriage license in Tennessee. Now, what that will do is it will precipitate a lawsuit saying you must pass a statute for us. They're going to have to sue us and say, federal court, you have to make them pass a law because we want our marriage license. Now, I'm not against marriage licenses, but I think there are many who understand the gravity of the constitutional problem here, and many who would say, look, whether I want to have same-sex marriage licenses or not, I'm going to have them because I have chosen to do so, because the people of Tennessee have chosen to do so, not because some federal judge oversteps the bounds and the lines and tells me to do something he has no authority to do. And so we need to focus this issue to a laser beam to say, Supreme Court, overrule all your prior precedent and just come up with it and admit, I will pass a law for you. And if they say that, my friends, constitutional government is dead in America. I have tried to say to people, I care a whole lot about marriage. But as Justice Scalia said, I ultimately care more about who rules me. Because if they can tell my state, this law's invalid and here's your new one. Oh, that law's invalid and here's your new one. And oh, we don't like that law either and here's your new one. Then what else will they begin to tell me to do? And why else should we even have a legislature? Just send us down the laws you want us to have and we'll just follow them. We have to help our friends who don't care who marries whom understand that this is a grave constitutional crisis of proportions not seen in this country since the Dred Scott decision. This is worse than Roe versus Wade. Roe versus Wade, the court found a new right in the Constitution, and they said you can't have this law. Here they found a new right, said you can't have this law, and here's, by the way, the new law. Do you see how this case goes beyond what the court has done in the past? From saying no, 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 no to yes, you'll have this. This is the most significant Supreme Court decision I submit since Dred Scott. And if we won't take it on, then we don't deserve to live in this country. It won't matter who we elect as president. It won't matter who we elect to the legislature or who we elect as governor. We will be ruled by 9 unelected, unaccountable, unreplaceable lawyers on the Supreme Court that went to Ivy League schools. And I resent that because I went to a public law school. Now, I want to talk about something else. We're going to run out of time here in just a moment. But there was another bill sponsored by some friends of mine, House Bill 1412. You may have read about it. It was the Natural Defense of Marriage Act. And boy, I have been raked over the coals because I did not support that bill. But I will tell you, there were people supporting that bill who privately told me they didn't support the bill because it did things they didn't like. I'll just stop there. There are some very dishonest people in politics. I probably ruined your evening. But they are there. Let me tell you, there are so many things wrong with this bill, I don't have time to explain them all. But it attempted to compel the Attorney General to defend local officials who did not obey Obergefell. The problem with that is the Attorney General is under the judicial branch of government, and the legislature cannot make him do anything. He's like the governor. He can say, well, I appreciate your law, but I think it's unconstitutional. I think it's invalid. I'm not going to execute it. The Attorney General can say, I'm not going to defend it. And you know what? Within an hour of the decision coming out, the Attorney General said, we must issue same-sex marriage licenses. This is the law. So why anybody thought the Attorney General was going to defend a local official who got sued and dragged into federal court is beyond me. But they wanted you to think that this bill was going to give your local elected officials a legal defense at the state expense. And what they also didn't know is that it allowed your local officials to be dragged into federal court over issues like group health insurance for their employees. Let's assume you had a couple that got married in Ohio after the Obergefell decision last September, and they moved down and they went to work for your Register of Deeds. Ohio says they're married, and they say, well, we want group family health insurance. House Bill 1412 would tell the Register of Deeds, no, you can't do that, you can't have it. Well, I'll sue you in federal court. Okay. Well, the Attorney General will defend me. Oh, no, he won't. Oh, well, who is? Well, I guess the county attorney. Well, he's not going to waste his money defending something that we know is unconstitutional. Well, that's fine. Now, Register of Deeds, you give them the health insurance or you go to jail, just like Kim Davis. Nobody wanted to tell you that's what that bill did, but that's what that bill did. And it did it not because I dreamt it up in my head, but because Section E of the bill says, no state or local official shall give force or effect to any court order that violates Tennessee law. There it is, state or local official. Register of Deeds, assessor of property, has a gay employee that wants health insurance or wants to name their spouse as the beneficiary of the government employee pension plan. Can't do that. Well, then you go sit in jail until you're ready to. And by the way, the Attorney General isn't defending you, and the state's not paying for your lawyer anyway. Most people didn't know that about the bill. But that's what the bill did. Now, we need to move on. What can the legislature do? Well, there is a resolution, House Joint Resolution 529. It's being sponsored by Susan Lynn. Susan Lynn was the chairman of the House Republican Marriage Task Force to figure out what to do. And there will be a resolution that's already got, I think, 25 co-sponsors in the House that acknowledges and supports the lawsuit's adjudication of these important constitutional issues. It is the means by which they can say, we see what's going on in Williamson County, and by the way, we'll be filing on Thursday in Bradley County, and we may be filing in another county soon. And they're saying, we agree with these lawsuits. We agree they're raising constitutional issues. We agree the Supreme Court overstepped its bounds. We agree that you can't just take the words male and female out of the statute. You need to encourage your legislators to support that. There'll be another resolution, and it's called Resolution (?), because it hadn't been filed yet. It'll probably be filed this week, that urges Congress to take actions to rein in the Supreme Court. We have forgotten that Congress is supposed to represent us, and that Congress has powers and things they can do to represent us, to rein in the Supreme Court if they will, but they haven't. Now, part of the reason they haven't is because the Supreme Court lets them do unconstitutional things themselves. So it's a pat my back, I'll pat yours. You let me do unconstitutional things, and I won't remove you for office for doing them. We need to start pressing our members of Congress and saying, I don't care how nice you are, I don't care how pro-life you are, I don't care how pro-religious liberty you are. If you're not going to protect the Constitution, then nothing protects me. That's the thing that stands between me and the government. And when you won't honor and respect it, I have nothing. And ultimately, I'll lose everything. It's time we get serious. And this resolution will say to Congress, we want you to start doing things. And then we need to hold them accountable in November. What did you do? The legislature sent you a resolution. They asked you to do something. Part of the reason we've been encouraging counties to pass resolutions, and we have a pastor here tonight that got 40 pastors. Enoch Langford, I want to just acknowledge you here, and there may be others, but Pastor Langford heard me speak about this months ago. He got 40 pastors, from frozen chosen to jump the pews, to black, to white, and they got together in Dixon County and said, we want to speak to this larger issue. This isn't just about marriage. Yes, marriage is important. We're pastors. But we want to protect our Constitution because that's what protects us. And that's been going on in multiple counties, and they're passing these resolutions, urging the state to do something and to urge Congress to do something. And now the legislature is going to take what they've done and said, yes, we heard you, local county commissions. We're now going to send a message to Congress. And we're going to report back to you if Congress did anything. So that when you have your town hall meetings, we can say, what did you do about that resolution our county commission sent to the state that the state sent to you? What hearings have you had? What things have you discussed? What things are you debating? What things are you sending to us to rein in the Supreme Court? Don't talk to me about all these other little things you've been doing. I want to talk about the big thing. Who's going to rule me? If we don't get that issue of authority straight, nothing else will get done right either. Here's a fun bill by Senator Bell and Representative Lynn that requires students in public schools and colleges to use restrooms and locker rooms based on the sex in your birth certificate. Now that just seems weird to me to have a law that says boys go to boys' room, girls go to girls' rooms. But that's the bill. They'll probably face a tremendous amount of resistance on that, particularly because it applies to colleges. And as you know at UT, they don't know if you're a Z, a Zim, a Zer, a Zit, I don't know, whatever it is. But I will tell you that the law is actually on their side. A lot of people say, well, let's just accommodate. Let's just give a single-sex bathroom so that nobody sues us. Well, my friends, at some point we have to say, how far do I want to accommodate things? Sue me, and if I lose, I'll do it. But I'm not going to give ground voluntarily that I'm not required to give. We must slow down the nonsense. There's some bills dealing with birth control. The first two bills are, the first bill is by Republicans, the second by Democrats. Not that it matters, but they're now working together under Senate Bill 1958, which would allow pharmacists without prescriptions to dispense birth control pills to women for up to 3 years before they ever have to see a doctor. Now, in the bill as it's been filed, there is no age restriction. So your 14-year-old daughter, 15-year-old daughter can go to the pharmacist, ask for the prescription, and it would be up to the pharmacist to give it to them, and you would not know at all. Now, maybe they'll at least put the age of 18 on there, but that's how they filed the bill. Now, the premise is, and I understand it, that we don't want to have more abortions, so let's hand out more birth control pills. Because we have a problem with abortion, let's have another problem. Let's let girls take pills without any doctor advising them, working to make sure that they don't have some kind of medical problem that might be a problem, without them seeing the doctor for the next 3 years. Maybe engaging in a more promiscuous lifestyle and resulting in sexually transmitted diseases. There are several bills dealing with the disposition of fetal remains. Unless you've been in a coma or maybe living outside the United States for the last year, you've heard about Planned Parenthood and the sale of fetal tissue remains. So there are several bills on that. Senate Bill 2522 and 2568 actually are drafted in such a way that they violate the federal law that does allow for tissue to be given for research purposes and to charge a reasonable fee for storage and shipping. And this says you can't do that. So those bills will have to be fixed, but I do believe that there will be an effort to do something to make sure that, as best we can, fetal tissue is not harvested and sold by Planned Parenthood organizations in Tennessee. There are also some bills dealing with reporting requirements that try to strengthen the reporting requirements so that we'll actually know what people are doing and have a paper trail and be able to prosecute them. So those are those bills. There's also been quite a bit of flap over the last year about the teaching of religion in schools, and particularly the Islam and what's happening there. And there are 3 bills that are addressing that issue in various ways. I don't know which one will take precedent, but that's part of what we do on our website is we try to track the bill that's actually the one that becomes the primary bill so that you're not trying to follow 3 bills. We'll follow the 3 and let you know which one is really moving forward. Lastly, there are a couple of bills dealing with religion and professional licensure. And we've been working on this for a couple of years, but in 2014, the American Counseling Association changed their ethical guidelines. The ethical guidelines are actually the state's guidelines. We adopted them. And it prohibits a counselor from referring somebody to another counselor if the counselor does not feel that he can counsel the person in good conscience, consistent with their religious beliefs. That's been the rule forever. Somebody comes in and says, would you help me feel good about doing abortions? Would you help me feel good about jihad? Would you help me feel good about being a member of the KKK? Would you help me feel good about my sexual activities? In the past, you've been able to say, I think somebody else can help you better. Why don't you go see Dr. Jones down the street? They've said, no, can't do that anymore. Now, I will tell you, it is alarming to me that our Department of Health wants to accept state employees. If you're a social worker or a counselor that works for the state, essentially they're saying, we're not going to follow the federal law and do our best to accommodate you unless it's a burden. Just don't go to the work for the state. If you're a person of religious conviction, just stay away. That disturbs me. Now, I know sometimes it can be impossible to accommodate somebody. But the state seems to want to say, we're not even going to try. So I'll be talking to the Department of Health and some people in the administration to say, don't go there. Don't go there. People are not going to want to know that our state government says religious people with religious convictions don't apply for state government jobs. And then there's another bill. If you have a friend that is a licensed pastoral therapist, this bill passed, I don't know how many years ago, but now they're wanting to rewrite this bill to require that pastoral therapists undergo the APA's training on gender identity issues. Well, you can imagine that's not going to be consistent with what most pastors would think about that issue. So if you have a friend that's a licensed pastoral therapist, they need to know about this bill. Essentially, you can't have your license anymore unless you're willing to be brainwashed and sit through the APA's training programs. Hopefully we can kill that bill. Well, we're about out of time here. And I did have a question I think somebody brought up here. But one question that was turned in was the situation going on in Oregon and other places with florists and cake bakers. Do we have that problem here? Do we have a human rights commission that is going to start going after people and forcing them to participate in same-sex weddings and ceremonies and those kinds of things and fining them into bankruptcy? And the answer is no. In those states where that has been a problem, sexual orientation and gender identity has been included in the state's civil rights laws. Right now, our civil rights laws are the plain vanilla civil rights laws that are race, religion, ethnicity, national origin, those things. So right now, there isn't anything that they could take you to court over because sexual orientation, gender identity, and marital status are not protected classes in Tennessee. If they ever become protected classes, then we've got a problem. But right now they are not. So let me just ask, okay, we do have a couple of questions. Let me see here. Would House Joint Resolution 529 support the adjudication of a lawsuit to expand Obergefell to polygamous group? I think the question is, will this lawsuit get at preventing polygamous marriages, and will this resolution encourage the prohibition of polygamous marriages? And the answer to that is yes, sort of. The lawsuit is over the law as it exists today, not as it might exist further. But if we're successful in the lawsuit, if the court says, yes, your law is invalid, the Supreme Court said it's invalid, and the state of Tennessee says, fine, we're not passing a different law, and the Supreme Court comes back and says, and we can't make you, we messed up, we did what we shouldn't have done, we're reversing Obergefell, then our state is back in control of the marriage license laws in Tennessee. And we'll only have polygamous marriages if the legislature votes for them. So essentially the legislature is, through this resolution, asserting their right to decide what our marriage laws will be. So I hope that helps answer that question. Doesn't the Supreme Court disregard federalism and separation of powers on a regular basis, and aren't their decisions the final word? The answer is the Supreme Court does a lot of bad things a lot of times, but they've never done it to this extent, where they've actually said, and here is your new law we've decided for you. That's the really critical thing. Now, what I hear from most lawyers is they say to me, well, supremacy clause, the Constitution's supreme, and the Supreme Court said the Constitution means this, so at the end of that, David, leave me alone. But I agree the Constitution is supreme. The Constitution is supreme, not the court is supreme. And the Constitution says federalism is a true constitutional doctrine. Separation of powers is a true constitutional doctrine. And those doctrines are supreme. Even the Supreme Court can't violate them. Now, they can try, and the purpose of this lawsuit is to challenge that, to throw their own decision back in their face. And to say, you said the law was invalid, so the law's invalid. Now I dare you to make me pass a new one. Might they say, yes, we can, and we will, and you shall, and we'll send federal marshals in to start running your courthouse? Yes, they could do that. But when they do, you will know that we've turned a corner, and maybe the rest of the world will wake up too. So yeah, they can do that. But this was the first step to try to bring things back into alignment. Some people wanted to essentially say, you're not going to do it. But when you do that, you better have a plan B. It's like your kid. When you say, if you do that, I'm going to whip you. You better whip them because you don't have a plan B. We may have to get to something else. But we're going to trust the American system and process will work if enough people will wake up, stand up, pay attention, and insist that they do. And one advantage, I had some people saying, David, this lawsuit is nonsense. And it may be. Passing a law that throws local officials in jail and gets overruled by the federal court in 60 days doesn't sound like a real great adventure either. But at least state judges have a measure of accountability to us that they don't in the federal system. And I don't say that in a threatening way, it's just a fact. They run for election. They run for a retention election. The legislature can remove any judge with 2/3 vote so long as they state the reasons for removing them. If the Supreme Court of Tennessee says, yes, you are going to issue marriage licenses because we said so, and we are the Supreme Court of Tennessee, they can say, and that's the last opinion you'll ever issue because you just violated the separation of powers. You let the Supreme Court enforce their own rule. You're gone. Boom. Now, if the Supreme Court of Tennessee does that and the legislature doesn't have the guts to remove them, well, then bad on us. But they can. So this isn't like being in the federal court system. Let me tell you that for those of you who are physically present, there is a bill tracking document that we have out at our table that lists all the bills and more, and a little summary and analysis of them and the pros and cons of them. So we'd encourage you to pick those up. And please share this information with your friends. We need a whole lot of people who are understanding what's going on and understanding what we really are facing in this nation. So with that, thank you again. Thank you to our friends at Grace Chapel for facilitating the online thing. God bless you all, and we'll see you on the Hill. Good night.